All right, does anybody have any questions so far? Who wasn't here in person on Tuesday? All right, you all were here Tuesday? Okay. Who was not here in person Tuesday? You guys need to watch the video from Tuesday's class if you hadn't already. I explain a whole bunch of stuff about how this works and how we're going to handle everything, and I fear that if you don't watch that, you're going to be a little bit lost. So please make sure you do that. We did go ahead and start Tuesday with class content, so that's another reason you're going to want to watch that video so that you don't fall behind. Your quiz for this week is due Monday night, and it covers anything that's said in lecture and anything that I've posted for you to read for this week. All right, if there are no questions, then I'm going to do sort of a brief review of where we were on Tuesday, which was discussing all the different sources of law that we pull from. Again, if you weren't here Tuesday, the lecture outline is posted to the content module, so you can pull that up and follow along with what I'm talking about this morning. It'll help you in taking notes. So we talked about the different places, and if you look in your outline, you'll see that I did include some examples of the sources of law that we talked about. We talked about constitutional law. You'll see in your outline that I have put in there for you a couple of examples. One example is the First Amendment to the U.S. Constitution, which guarantees our right to certain freedoms of speech, of religion, of assembly. And then the second thing I think I put in there is the authority that the Constitution gives the federal government to regulate commerce between the states. That's known as the Commerce Clause. Those are just examples for you to reinforce what we were talking about before, and I am missing part of my outline. There it is. All right, then we talked about statutory law, which, if you'll recall, statutory law was law that is passed by a legislative body. So that could be at the federal level by the United States Congress or at the state level by a state legislature. I've included an example of a Georgia state statute for you on the top of page 2 of your outline, which is the Georgia statute on battery. And I'm not expecting you to memorize or know what constitutes battery under the Georgia statute, but I want you to see an example of what a legislative body might write into law. So they have codified the offense of battery as when a person intentionally causes substantial physical harm or visible bodily harm to another. That's kind of a general definition, right? So it would be up to the courts to decide in each individual case whether or not the facts of that case meet the statutory definition of battery. That's how that works. Just looking at that first subpart A, the definition of battery, what would be some of the things that if you were on a jury in a battery case, you would be having to decide based on the facts? What are some of the things that you as the jury might have to decide reading that definition? Let's say that I'll give you a more concrete example. Who'd I bust up in the head Tuesday? Somebody. Or with a crowbar. All right, I've done that, and I'm on trial for that. The state has got to prove that that my actions fit this definition of battery. So the jury would be having to decide what kind of things. Reading that again, what do you think? Person commits the offense of battery when he or she intentionally, that's the first word I see. You as the jury would have to decide whether or not what I did was intentional. Causes substantial physical harm or visible bodily harm. So we'd have to see if what I did to Mr. Wilmot, if there are facts that they can put into evidence that prove that. All right, so that's how this battery statute would play out in court. This is all just for your understanding of how this stuff works. I also included another example of statutory law in there, which is from Title VII of the Civil Rights Act of 1964, which the text of the statute says it's unlawful for an employer to fail or refuse to hire or to discharge any individual or to otherwise discriminate against any individual because of such individual's race, color, religion, sex, or national origin. All right, that's the statute that governs employment discrimination. So if I believe that I've been fired by CSU because I am a male and I sue them under this statute, you all are on the jury. One of the things you'll have to decide is whether or not my discharge, my firing, was because of my gender, my sex. So take that a step further. If you're my lawyer, what kind of facts would be good for our case? You can assume some facts, because all I've told you is that I think I got fired because I'm a male. What kind of evidence might you like to see? Might we like to introduce?
Average pay of all the teachers.
Louder, Warwick?
Average pay of all the teachers.
You want to see what everybody else's pay is? Yeah, you want to be able to compare the terms of my employment with others, right? I mean, discrimination is treating somebody differently, by definition, differently than other people based on a characteristic. So we need to know what the other makeup is of the faculty. Maybe it's an all-male faculty. I'm the only guy here. That's worse fact for me, right? Maybe it's an all-female faculty. I'm the only man and they fired me. That's a better fact for me. That's right. We're going to see what everybody else is doing. What else are you going to want to see?
Who else got let go?
Who else got let go? If you had somebody, let's say we put Dean Kidder on the witness stand. She's my boss. She's the one that fired me. What are some things you're going to want to ask her? What are you going to want to know about me? What kind of employee was he? Yeah. What were his reviews? What do you say the reason is that you fired him? If she gets on the witness stand and says we fired him because he's male, then what are we doing, right? I win my case. She's obviously not going to do that. So she's going to give you what her reason was. He was late for class. He got terrible reviews. He doesn't know what he's doing. He used offensive language. Those type things that might be what you'd be interested in. You probably want to see my employment file, right? What kind of performance reviews have I gotten over the years? Have I gotten in trouble before for anything? If you're my lawyer, then we're going to have something a little bit better than, she's a woman, I'm a man, and I just think she hates men, right? I got to prove that. So I may need, as Mr. Wilmot said, some comparison. Maybe I can show how I was treated differently than employees of a different protected class. Maybe there are emails between Dean Kidder and somebody saying we've got to get rid of Tebow. That because he's a man, I don't know. That'd be too smoking gun, I guess. Emails, witnesses, letters, any kind of communications that might be good evidence for me. I've gotten off on a little bit of a tangent, but I'm trying to sort of make this come to life a little bit and show you how something as dry as what Congress would pass in a statute is actually, how that's actually used and applied in the real world. So again, just giving you examples of statutory law. We talked about administrative law. Administrative law are rules promulgated by administrative agencies of the government, not just any administrative agency, but a government administrative agency. So on the federal level, I gave you the example of the IRS, the Environmental Protection Agency, the Occupational Safety and Health Administration. All those are administrative agencies, and they make rules to help carry out the job that they're tasked to do. Some examples that you will see in your outline, top of page 3. There is a federal rule put out by OSHA. This is law. Ladders shall be capable of supporting the following loads without failure. Each self-supporting portable ladder, at least 4 times the maximum intended load, except that each extra heavy-duty type 1, and does that just make your head explode, right? But that is an example of law that is binding that anybody in the workplace has to follow. You don't find that in the Constitution. You didn't find that in the text of any statute that Congress passed, but you do find it in the rules of administrative agency. That makes up the body of law known as administrative law. An example of state administrative law, I've published an excerpt from the Georgia hunting regulations on turkey season. Runs from March 30th to May 15th for private land, different dates for public land, limit of 2 gobblers per season, 1 a day. That wasn't in the Constitution anywhere. That was not passed by the Georgia legislature. That was a rule made by the Georgia Department of Natural Resources, and that is administrative law. Case law, we talked about that those are written decisions of courts as they interpret laws. And an example of that is going to be the Brown versus Board of Education case, which you've hopefully read talk about in a minute. So I'm going to skip that for now. A few new points I want to make today, and this is just, again, sort of by way of background and making sure that we're all speaking the same language on this. Apologize if this is a little bit elementary, but when we talk about federal law, we're talking about a law passed, well, let me ask you, based on our discussion Tuesday and this morning, if I say federal law, what would that consist of? It'd come from different places. What's one source of federal law? All right. Well, what does Congress pass? Legislation, and that falls under the category of law that we talked about here of statutory law. So laws passed by Congress is an example of federal law. Good one. What else? Where else might we look to for federal law? Case law from not, yes, the Supreme Court, but any federal court. So that's exactly right. The Supreme Court is an example of a federal court. And so that would be a source of federal law. What about the law I talked about Tuesday where the city of Columbus talks about how many chickens I can have in my yard? Is that a source of federal law? No, because it wasn't passed by a part of the federal government. Federal law, that's the law of the United States. That's the Constitution of the U.S., federal law. Statutes passed by Congress, federal law. Rules made by federal agencies, federal law. Cases decided by federal courts, federal law. State law, on the other hand, is going to be just the other side of the coin. The Georgia Constitution, that's state law. Statutes passed by the Georgia legislature, state law. Decisions of Georgia courts interpreting Georgia law. And then rules made by Georgia agencies. That's Georgia administrative law. All right, let's talk about another distinction of law categories for a second. You have probably all heard at some point the term civil law and the term criminal law. All right, these are exclusive categories. It applies to federal law and state law. Criminal law, the easiest way to describe it is to tell you what criminal law is, and then civil law is going to be everything else. But criminal law involves the body of laws of either the state or the federal government that defines what crimes are and what the punishments are. They're offenses against society. Criminal law is between criminal law is between an individual and the government. The state of Georgia has made murder illegal. That's a criminal law. If I murdered Warwick with the crowbar, then I forgot my point because I'm a stone cold killer. I totally lost my train. Oh, that's not between me and Warwick, although he is my victim. He's not suing me for murder. The state of Georgia is prosecuting me for murder. That's where I'm going with that. Criminal law is between me and the state or me and the United States of America. All right, civil law is everything else. Divorce law, contract law, construction law, tax law, tort law, personal injury law. Everything else besides criminal law is civil law. Now, here's something that can get a little confusing. One act or one set of facts, let's say one act, can trigger liability in both civil law and criminal law. Okay? So the best example I can give you of this is O.J. Simpson. O.J. murdered his ex-wife, right? Let me put it a different way. She died, and he was accused of killing her and her boyfriend. So he was arrested by the state of California and charged with murder. That's under the criminal law of the state of California. That's between him and California. Society expects that we don't kill other people unnecessarily. He did that. That's a violation of criminal law. Her family sued him as well. That was no longer between O.J. and the state of California. That was between O.J. and Nicole's family. That was civil law. So only one act of allegedly killing got him two lawsuits. One a criminal lawsuit brought by the state of California, and one a wrongful death lawsuit brought by her family. So the same act can have repercussions in both civil law and criminal law. We also have some laws that make the same conduct criminal, but there are also civil laws that make that same conduct unlawful. I'm not going to say criminal because that would be a criminal law. Unlawful. Example, it is a crime to assault somebody. So when I took the crowbar to work, I have violated a criminal statute on assault, among other things. But there's also a civil statute on assault that I've violated as well. The reason we have both of that is Warwick's interest in holding me responsible is what? What does he want? He might want compensation, right? I mean, he wants me to be punished, I would think. Compensation. He might want money for his medical bills, pain and suffering, things like that. That's not the state of Georgia's business. The state of Georgia's interest in charging me with the crime of assault is what? What's the purpose of that? Punishment. That's one. That's a big one. Why else does the state want to prosecute people who attack other people?
So it doesn't happen.
Yeah, deterrence. Keep other people from doing it. That's exactly right. So the interests of the state of Georgia and the interest of Mr. Wilmot are different. And that is why the state of Georgia can charge me under the crime of battery. He could sue me in a civil court for the tort of battery. Same conduct, same act, but I'm responsible to the state for the crime and I'm responsible to him for the tort of battery. Again, not testing you on these ins and outs. This is all just to try to illustrate how these things work. We're going to talk about in this class criminal law 1 week, maybe 2 weeks. So everything else we talk about in the class is going to be civil law. Employment law, environmental law, property law, all that is civil law. I just want you to be able to speak the right language when we're talking about those things. I'm not going to get too much into the constitutional features that affect business. This is in your outline, and it is important for you to know, so I'm not dismissing that, but I don't know that we need to talk so much about it. You guys know about how our government is arranged in terms of separation of powers and checks and balances. You understand that, hopefully, that the Constitution set up what they intended at the time would be a limited form of federal government, meaning the Constitution said, federal government, here are your powers. We're spelling them out. Everything else belongs to the states. And the intent was that the states would retain most of the power over decisions, and that the federal government would do things like run the mail, run the army, things that might concern federal interests. What happened over time is that communication and technology made geographical borders less relevant, right? Nowadays, if we're in business, we're on the internet, we're in business everywhere. And so that sort of bloomed into the federal government, them being able to regulate commerce between the states. That's one of the things that was delegated to them. That really became a really huge responsibility, because almost all commerce these days could be said to be interstate commerce. So in that way, we started out with what was really a very limited form of federal government to today. I think we think of the federal government as more in our business than state governments are. That's debatable. There are also some freedoms that are guaranteed in the Constitution that we just need to touch on real quick. We talked Tuesday a little bit about speech and how that's protected. But I think all the examples from Tuesday were of individual speech. I wore a offensive armband. I yelled fire in a crowded theater. But speech can be commercial as well. My business might put billboards up. No person said that, whatever I put on my billboard, but it's certainly speech. Businesses can contribute to political campaigns and causes and committees. That's a form of commercial speech. That is, one, guaranteed by the Constitution to have the right to freedom of, but also limited in some ways that relate to public safety and fairness and that sort of thing, right? So we thought about it Tuesday in terms of individual speech. I just want to broaden. I want you to just recognize that commercial speech exists also. It's also protected by the Constitution. It's also limited in some ways. If you had to guess which is protected more by the courts between personal speech and commercial speech, what would you guess? What enjoys more protection? Personal speech enjoys more protection than commercial speech. That's right. You've heard of due process. This is another thing that's guaranteed by the Constitution. Due process really means fairness. Fairness in the way that laws are carried out, fairness in the way that the government behaves. It would be a violation of my due process for the Columbus Police Department to come in here and arrest me this morning without telling me what I'm arrested for. They can't just go stick me in jail without going through the legal process. That's due process rights. And then also equal protection is guaranteed by the Constitution, and that is something that we do see affecting us in business a lot. And that was at the heart of the Brown case that we're going to talk about in a second. So, before we get to Brown, I want to show you a couple of things in the materials All right, note right here on these Georgia criminal statutes, this was just just to give you an example of a criminal statute. I'm not asking you in your quiz anything about robbery or battery or anything like that. It's just that's just an example. Same goes for the Georgia administrative law example. That's just an example of administrative law. I'm not testing you about, you don't need to worry about the different seasons of hunting animals in Georgia. All right, same goes for these next two charts that I'm going to show you. I want to talk a little bit about how the court system is arranged. So, just like we have the federal government and each individual state government, we also have separate court systems. It's not really important that you know which court system a case necessarily belongs in. I just want you to appreciate that the state of Georgia's court system, the state of Minnesota's court system, is different than the United States court system. However, it is possible to jump from one to the other, depending on the subject matter of your case. So if I wanted to sue CSU, I'm a Georgia resident, CSU is a Georgia entity, I could sue them in the Georgia court system. I could also sue them in the federal court system if my case involved a violation of federal law. These are just examples again. If Mr. Meyer, if I need to sue him, he's not a U.S. citizen or a Georgia citizen. Where can I sue him? I can sue him in a Georgia court if he's done something here. If what I'm suing him about has some connection to a violation of Georgia or U.S. law. I could sue him depending on what I was suing him for in federal or state court. Not important, the distinction. Just want you to appreciate that there is crossover between the court systems. So having said that, let's look at the federal court system first. In every court system, you have an entry-level court, and then you have appeals courts. So your entry-level courts are called your trial courts. Your trial courts are where you're probably more familiar with that. That's where the witnesses take the stand. That's where the judge bangs the gavel and overrules objections. That's where opening arguments take place, closing arguments take place. That's where the juries are. That's where the verdicts are. Those are trial courts. The purpose of the trial courts as entry-level courts to the court system is that trial courts are where we determine what happened, what the facts were. At my trial for attacking Mr. Wilmot, some of you who saw me hit him with the crowbar might be witnesses. You might be called in to give sworn testimony. I saw Tebow take the crowbar to his head. He was screaming, "I'm going to kill you." That's where we decide what happened. The appeals courts, which are the courts that are above the trial courts, they decide whether or not the trial court applied the law directly. Correctly, not directly. Correctly. Okay, so let me give you an example of that. At my trial for attacking Warwick with the crowbar, the state of Georgia tried to introduce evidence that I have done this before, that I've attacked students multiple times before. All right? I say, well, there's a Georgia law that says prior acts are not admissible in my criminal trial for this act. So the court should not have allowed the state to put that evidence in. But the judge allowed it. on my appeal, I'm not going to appeal that I didn't do it. I'm not going to appeal that I didn't hit him. I'm not going to appeal that I didn't say I'm going to kill you. Those are all fact. That's what happened or didn't happen. The trial court decides that. The appeals court would decide, did the judge apply the law correctly when he or she allowed all this other evidence to be testified to? All right? So another way of saying all this is trial courts decide issues of fact. Appeals courts decide issues of law. Let's say that, let's don't do that. You can appeal from what happens at your trial up to the next level of appeals court. And then you can keep going as long as there's another level of appeals court to go. In the federal court system, if you don't like what happens at the district court level, these are trial courts in the federal system. District courts or trial courts in the federal system. You don't like what happened there, you can appeal to the the United States Circuit Courts of Appeal. That's that middle level. If you don't like their decision, then you get to appeal to the U.S. Supreme Court. If you don't like their decision, you're out of luck. That's the end of the road. All right, let's look for a second at the Georgia court system. Now this one's going to be a little more, how do I turn this around? Well, does everybody have that in front of them? Actually, hold on. How do I do it? Where, over here?
No, over there, all the way to.
Come show.
Yep.
Rotate.
There you go.
Thank you. Sorry about that. Told you I'm very challenged. All right, so before you freak out on this, I'm not asking you any questions about how the Georgia court system is set up or names of Georgia courts. I just want you to see an example of how a state sets up their court system. Okay? There are a lot less courts in the federal system, right? We just had the district courts that were the trial courts, the circuit courts for appeal, and the U.S. Supreme Court. In the state court systems, this is Georgia's. Alabama's going to look different than this. Minnesota's going to look different than this. Everybody can do it their own way. In Georgia, these bottom two rows are our trial courts. This is where the trials happen. This is your entry level to the Georgia court system. So if you're wondering, well, which court do I get, where do I start? Depends on subject matter. So I'm not testing you on this, but just for example, magistrate court, a municipal court, that's like small claims court. Disputes that are worth less than $15,000. Violation of a city ordinance. I had too many chickens in my yard. I'm going to be taking the municipal court. Recorder's court is the first stop when you get arrested. That's where you make your first court appearance. Juvenile court, you're under 18 and you're charged with a crime, or you need to be removed from your parents because it's not safe, you'd start out in juvenile court. Probate court, that's where we go for guardianships and wills and contesting estates and all that kind of stuff. State court and superior court are more courts of general type jurisdiction. If you are filing an adoption, if you're suing somebody over a contract, if you get charged with a major crime, all that would be in superior or state court. So, if you don't like what happened at your trial in these bottom two rows, then you can appeal to the Georgia Court of Appeals. That's our mid-level appellate court. If you don't like what happens at the Georgia Court of Appeals, you can go to the Georgia Supreme Court. Now, if you don't like what happens in the Georgia Supreme Court, can you jump over to the federal court system? Sometimes, depending on what the subject matter was. If it involves a federal law or the U.S. Constitution, then you might be able to keep on going from the Georgia Supreme Court over to the federal court system and then up that ladder. Again, not testing you on that, just want you to sort of see how all this is set up. Anybody have any questions on this? right, so just to review, everything from Georgia court system down for this week is just examples. Your quiz is going to be over the lecture outline, anything I'm saying in class, and the case of Brown versus Board of Education. Everything else there is just for your, just for by way of example. All right, that brings us to Brown versus Board of Education. So let's see if we can put some context to what we've talked about the last couple days. Hope y'all noticed that this case was not even 3 pages long, right? The actual text of the Supreme Court decision is like 80 pages long. So I cut out a whole bunch of stuff for you and hopefully cut it down to just what is relevant for our discussion. So, in a lawsuit, the person who brings the lawsuit, who does the suing, is the plaintiff. Again, just more vocabulary, basic, speaking the same language. The person that the lawsuit is brought against is the defendant. In a criminal case, the plaintiff is going to be who? Who's the plaintiff in my criminal case, my crowbar assault case? Say that louder.
The victim?
Not the victim, because criminal law is between me and who? The state of Georgia. So the state of Georgia is the plaintiff. In any criminal case involving state law, the state's the plaintiff. The defendant is the accused perpetrator. In the civil case that Mr. Wilmot brings against me for compensation, he's the plaintiff. He's suing me. I'm the defendant in that case too. Probably better as a rule to be a plaintiff than a defendant, right? Generally speaking. All right, so in this case, who's the plaintiff in Brown versus Board of Education? Say it louder.
Well, no.
Brown, you're right. Brown is the plaintiff. They're the ones who brought the suit. And then the defendant would be Board of Education. That's right. They're the ones getting sued. The plaintiff actually, though, in this case was more than one person. Brown is just sort of the name, the collective name that's given to him. Who were the plaintiffs? Parents of students where?
In the school system.
In the school. What kind of school system? A public school system. That's right. All right, they were the parents of students in a public school system. And what was their beef? What were they suing about? Say it louder. Say it louder, work.
They weren't allowed to attend school at the public school.
Who wasn't?
The students, the black students.
The black students weren't allowed to attend public schools with the white students. Right. Okay. And that was the group of plaintiffs. So these parents couldn't just sue the Board of Education because they didn't like the policy. They had to be able to point to the court to where the law had actually impacted them. So before they sued the Board of Education, what did they do? What did they try to do? They attempted to enroll their children into the public school system of the school where they lived, which would have been, for these black plaintiffs, it would have been a white school. All right, they were denied. Once they had been denied and had been negatively impacted by the law, then they could sue. So that's exactly right. They brought suit against the Board of Education. So you know from looking at the court that wrote this opinion, that decided this case, are we in the federal court system or the state court system? Federal court system, that's right. We do have Kansas residents suing a Kansas city government, state government, but they're doing it in federal court because the law that they alleged is in question here is federal law or state law. Who said federal? That's right. Specifically, which federal law is it that the plaintiffs are claiming the defendants are violating? Say it louder, Ms. Delaware. The 14th Amendment of the U.S. Constitution, which is federal or state law? Federal law, that's right. That's exactly right. They are alleging that they have violated the 14th Amendment of the U.S. Constitution. What does the 14th Amendment protect? What does it guarantee us? Say it louder. Equal protection under the law. That's right. That's what the 14th Amendment guarantees us. So, can we look anywhere in the Constitution and see where it talks about segregation of public schools? No. It's not in there. But what is in there is that each citizen is guaranteed equal protection of the law. And the plaintiff's claim is that by having separate schools run by the government, public schools, that the students who are not allowed to go to the other school are being denied the equal protection of the law. That's their claim. So this went to trial in the district court level of the federal courts. And they would have presented evidence about trying to enroll their students in the classes, that they were denied where they lived, that this is where they would have gone to school if we went by geography and not race. They would have put on testimony about the school system's facilities and the nature of the black schools versus the white schools. You would have heard evidence about whether or not they were equal or not, because under the law as it existed, separate but equal was constitutional. So that would have been some of the evidence that would have been put on at the trial court level. Who won at the trial court level? The plaintiffs or the defendant? Say that again. The Board of Education won at the trial court level. Is that what you said? I'm just having trouble hearing, so I apologize. I don't know. I think I'm just getting old. So y'all may have to yell at me. Or else have everybody move down 3 rows. The Board of Education won at the trial court level. All right, so the plaintiffs lost. They appealed to the middle level appellate court. They lost again. Then they appealed to the Supreme Court. And this decision that you read is the written opinion of the U.S. Supreme Court. Now, back up with me for a second. What was the justification that the court, at the trial court and the first appellate court, why did they hold or find in favor of the Board of Education? What was it that they were relying on in finding for the Board of Education? Yes, sir. You weren't raising your hand? Separate but equal. All right. And what does that mean? Where did that come from? Say it louder. Plessy versus Ferguson. What was that?
Separate equal schooling, meaning that the facilities will be treated the same but in different areas.
Okay. What did Plessy versus Ferguson is what kind of law? Is it statutory law? Case law. That's exactly right. So case law that has interpreted the law previously, remember, is binding on future courts for the most part. We see that they did not follow the precedent in the actual Supreme Court case, but the lower courts did. The lower courts said, we have case law that has been decided by the Supreme Court before that says that as long as public institutions provide equal opportunity or equal tangible facilities, that is legal and constitutional. That does not violate the 14th Amendment. That's what Plessy versus Ferguson said. Okay, that was a precedent that those lower courts had to rely on. Well, they didn't have to, but they did. So now we get to the Supreme Court, and the Supreme Court says, not so fast. As an aside for a second, and I think this is a question on your quiz, the Supreme Court doesn't have to take every case that's appealed to. Most appellate courts don't. Some of them are required to, some of them not. That's not the part that's on the quiz. The part that's on the quiz is, why did the Supreme Court say that it decided to take this case? They tell you in the opinion. What was it about the question that they had to decide that would have tempted or caused the Supreme Court to say, yeah, we'll take this one? They say in there, the bottom of the first page of the opinion, because of the obvious importance of the question presented, the court took jurisdiction. So the court is saying, we felt like this issue was substantial enough, important enough, that we need to weigh in. So the court talks at the top of page 2, the court starts taking you through their rationale of how they arrived at their decision. So remember I told you Tuesday that if a court is going to overturn precedent or go against precedent, they're going to need to articulate why they're departing from decisions or law that's already been decided and settled. They got to justify it somehow. They got to at least show you their math. So the court starts out doing that by looking at what the 14th Amendment meant when it was passed. In 1868, that's when the 14th Amendment was passed. All right. What did the court say about, so the court rewinds to 1868. Okay, let's go back then and let's think about what the folks who wrote this law, who wrote the 14th Amendment, how would they have viewed public education? How can we look at their intention in the context of public education? So what does the court say about public education in 1868? Say it again. It was non-existent. It wasn't really even a duty of the government in 1868 to educate the public. That wasn't even something they undertook. It says most education of children was done privately. It was not done by the states, any state. So that's a pretty big difference right there. Now we're looking at what's the government's responsibility when it comes to public education and equal protection. We're looking at it in a way that did not even exist in 1868. They go on to say that education was not looked at to even be as important as it is in the 1950s and even today. All right, and so it doesn't get them very far to start thinking about what the authors of the 14th Amendment meant, because really there's not much history on it, and education was not a responsibility of the government then, so we're not going to be able to get very far on that. So then the court turns to looking at prior cases, the precedent, in particular, Plessy versus Ferguson. So when courts consider prior decisions, when they look at precedent, one of the things they have to do is to determine these old cases, or these previous cases, are they more like this case? Or are they more different than this case? Can we distinguish this case from those in meaningful ways? The court did distinguish Brown from Plessy versus Ferguson in one real important way. Anybody pick up on that? Say it louder. Transportation what? You're right. All right. So Plessy involved which one? transportation, right? So when that court said separate but equal is constitutional, that was in the context of public transportation. The lawyers for the plaintiffs in this case said, hey, Supreme Court, we're not talking about riding a bus. We're talking about educating our youth. This is a wholly different thing. That was their argument, and that was a successful argument for the Supreme Court. What is it? The court kind of goes through. The court goes through some things that we can measure, like size of buildings or number of teachers, tangible factors. Does one school have air conditioning? Does the other school have air conditioning? But then the court goes on to say that really looking at tangible factors is not going to be enough, right? What is it about education in the intangibles that makes separate but equal not possible? They talk a lot about this. Anybody?
Results after school, like how educated the people are from that school.
I mean, and that matters why? Hold on, go ahead, because I might not have been following what you're saying.
Yeah, like, I mean, they were talking about how a lot of the black community was illiterate and not very intelligent in the school, so just ways that, like, you can't really, I guess, measure the results of the teachings.
Boom, that's right. The importance and the impact of education, we can't measure that on society, on a group of people's future. We can't put a measure on that. They go on to say that education is perhaps, arguably, gone from not a responsibility of the government at all to maybe the most important responsibility that the government has. That's a huge change from when the 14th Amendment was passed and from when Plessy was decided. There was a number of years between Plessy versus Ferguson and Brown versus Board of Education. That's exactly right. We must consider public education in the light of its full development and its place in American life. It's required in the performance of our most basic public responsibilities, even service in the armed forces. It's the foundation of good citizenship. It's the principal instrument in awakening a child to cultural values. The court writes, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. So they're setting up their reasoning for why they're about to go against precedent. They're going to overturn this separate but equal doctrine. Another point that I think is important that the court makes is the message that children receive when they're told that they're going to be segregated, that separate but equal is okay. The message that one group is told that they're not good enough or as good as another. That has a really powerful impact in and of itself. But when that message comes from the government, then the power is amplified considerably. It's one thing for somebody to be told you're inferior. It's another thing to have your government tell you that. And so the Supreme Court is saying, if we uphold separate but equal in the context of public education, that's what we're doing. And we don't think that the 14th Amendment's guarantee to equal protection means that the government can have separate but equal public schools. Separate but equal public schools violates the 14th Amendment of the U.S. Constitution. And that is the example we have of case law. Brown versus Board of Education is still the law of the land. And it carries on today. Separate but equal has been struck down in almost every other area, not just public education and transportation, that kind of thing. But that was an example of how case law works, where the Supreme Court had to interpret the Constitution as it applied to a certain set of facts, and it had to navigate previous court decisions that went against what the Supreme Court said. They were different than what the Supreme Court said. Anybody have any questions about it? All right, so your quiz is going to be over just some of the basic stuff from lecture and then some of the main points of Brown versus Board of Education. I want you mostly to understand how the court got from A to B, what their reasoning was, what their justification was, why they did what they did. For this week, you got a quiz that's due Monday night. It's 20 questions. It's multiple choice, true, false. You can use your notes and the outline and the case, but nothing else. You have a discussion question that is due, and that's all we have for this week. Next Tuesday, we'll start a new topic. We're going to talk about litigation, court cases, the litigation process, things like that. I did have a question in my email about discussion questions. You're not required to respond to what other people write. I just want you to answer the question. You're welcome to respond to what other people write, but you're not required to. All right, if there are no other questions, then I will see y'all next week. Oh, who came in late? Found out where, hold on. Came in late, let me know. Don't leave without telling me. All right, yes, sir, name? Mr. Alexander, I got you. Who else? Miss Abeda, I think, was in the back, but I don't know where she went. Somebody else came in late. I got you, right? What was your name? That's right, Rose. Cole. Miss Cole. You did, okay. I knew there was somebody else.
I was here when it started,
Oh,
but
you did, that's right.
I just wanted to let you know, so my dad was here last week. So over the next couple of weeks, we're going to be in and out of court doing different stuff. So I mean,
Oh, excuse me.
I appreciate that. Thank you.
Absolutely.
Yes, sir.
Thank you for letting me know.
Yes, sir.
I'm really sorry.
Absolutely, I appreciate that.
Good stuff. Normally, I like to know ahead of time, but if you need to let
Yes, sir,
me
I'll shoot you an email.
But if you need to let me know after the fact on
Yes,
something,
sir.
I'm okay with
Yes,
that.
sir. I'm moving out to my mom's house this week, so.
All right.
Yes, sir.
Well, I totally understand.
Yes, sir.
I'll cut you slack on
I
that.
appreciate that.
Yes, sir. Yes,
Hi,
ma'am.
I wanted to introduce myself. My name is Miracle LaFavor.
Okay, I read your introduction last night. Very
Oh,
interesting.
thank you.
You have a lot of experience.
Oh, yeah. I guess you could say that.
I like that.
Thank you. But I wanted to ask, other than watching the video, is there anything else? Because I wasn't here. I just
For
enrolled.
this week,
Mhm.
just watch that video, and then you're going to need to read the outline if you feel like you need to,
Mhm.
and then the case.
Mm.
That's the only things. Oh, and you have a discussion question, which you've already done.
Okay,
That's
thank
right.
you.
Yeah, that's all there is. The way every week there'll be this,
Mhm.
and it'll tell you everything we have to do.
Okay,
It'll
thank
tell you
you.
if there's a quiz, an assignment, all that kind of stuff.
Mm.
And have you watched Tuesday yet?
No, not
Okay,
yet.
do that, and if you have questions, let me know. But
Okay,
it'll
thank you.
explain how everything works.
Perfect. Nice
All
to
right,
meet
thank
you.
you for introducing yourself. Nice to meet you too.